Good morning, everybody, and thank you, Paul, for inviting me here today to present the first session. My name's Caroline Sumner, and I'm R3 CEO. For those of you who aren't familiar with R3 and the work which we do, we're the trade association for the restructuring and insolvency profession. Our members come from all areas of the profession and include insolvency practitioners and their staff, lawyers, restructuring professionals, and others who provide services on the periphery of the profession. R3 really is at the heart of the insolvency profession, and we have a pivotal role to play with a number of key stakeholders, including the Insolvency Service, HMRC, the regulators and legislators. We've always held that an effective insolvency regime is an essential part of a fully functioning economy. It promotes economic regeneration, saves jobs, and creates a confidence and public trust which underpins trading, lending and investment. I was therefore really pleased today to be able to come and moderate the first papers, and our policy team back at R3 is really engaged in ensuring that our insolvency regime is really fit for purpose and that our professionals have the tools that they need. So I'm really interested in the thoughts and ideas that are going to be discussed today as we shape the future of our profession. So I'd like to introduce our first speakers. We have Dr. Kayode Akintola, I hope I've said that right, and Dr. Sofia Ellina from Lancaster University. Sofia is currently teaching company law and European Union law. She's also recently assisted the Insolvency Service as a senior research associate. Her published studies focus on corporate insolvency procedures in both the UK and Cyprus. Dr. Kayode Akintola is from Lancaster University as well, and he's a barrister with experience in contentious and non-contentious commercial issues, whose research and teaching interests cover a range of transnational commercial law issues. And I also want to point out that Professor Millman was also involved in producing this paper, but he's not been able to join them today because of teaching duties. So I'd like to introduce you both to present your paper. We're then going to have a second paper, and I'll introduce the author of that when she comes up. And then at the end, we're going to leave a good 20-25 minutes for questions. So as we go through and listen to what our presenters have to say this morning, please take notes, and we welcome your questions at the end. Thank you.
Right. Very good morning to everyone, and it's really good to be back doing this in person. And thank you very much, Caroline, for that introduction. Now, as she said, Professor Millman is one of the key contributors to our paper, but being the true master in the art of delegation that he has sent his apologies, sent his best wishes, but of course has sent the B team to do the grunt work of presentation. So here we go. This morning, Sofia and I will be speaking on the subject, should we rescue in insolvency? And we propose to do this in three parts. First of all, I will be doing a quick overview of some of the key issues that drove this paper. In particular, our focus today is on whether we need to shift our policy efforts towards liquidations. And we're largely concerned with creditors' voluntary liquidations, but would also talk about compulsory liquidations in the course of this paper. Now, in the second part of the paper, Sofia will be providing some evidence for this by comparing certain outcomes in administration with certain outcomes in creditors' voluntary liquidations. And finally, I'll be looking at certain incidences in liquidation, but that perhaps in the face of it suggests that there is scope for further legislative intervention, in that particular paper. Right. On the notion of whether we should rescue in insolvency, it's perhaps clear that the answer to that is yes. So what we've done is to capture a title that is decidedly provocative, like 1960s advertising agents in Madison Avenue. Because of course the question is not whether we should rescue in insolvency. More to the point is how we should continue to pursue our rescue efforts. To our mind, having invested so much effort in the rescue agenda, which is great, but we spent the last 18 years in particular engaging in reform after reform, in particular in the field of administration, it is our view that a properly calibrated liquidation regime would not only enhance that rescue ideology, but would also enhance confidence in the wider insolvency framework. Now, we say this for 4 key reasons. The first, of course, is the data before you, which is the idea, or indeed the reality, that many insolvencies are liquidations, and in particular, many of them are CVLs. Now, if that is the case, it would make sense that we should start to invest some further efforts in this particular procedure. Because after all, what is the point of trying to drive confidence in the wider insolvency regime if we cannot engage with these particular procedures that stakeholders are more likely to have interaction with? So that's one key reason for us. And of course, I'll probably stress that this paper is largely concerned with corporate insolvency procedures. So just in case you are waiting for some talk on personal insolvency, you would have to listen to Professor Walton's paper in a few minutes. Now, the second key reason for suggesting that now is the time for a policy shift is the value that liquidations in itself presents. Now, liquidations promote market efficiency. Now, we are largely concerned with the cost benefits of liquidations. Not to use a morbid expression, we are thinking about how to get companies and indeed their distressed scenario resolved in a very quick and decisive manner. Some would call it cheap burial. But the point is that if we can engage in an efficient recycling of assets back into the economy, by way of distributions, of course, then everyone is better off. We can improve outcomes, we can improve creditor returns potentially. So that's another arm to our thesis, as it were. Now, the third point is that liquidations serve the purpose of promoting market integrity. And on that point, we're concerned with the creative destructive power of liquidations. Now, we've already talked about some of the business-saving measures that were timely and required in the course of the pandemic, but we now have an insolvency ecosystem that is pregnant with many distressed entities. So there's a question of what we do with them. How do we resolve that? And we know that liquidations have this creative destructive value. Of course, the end result is dissolution. It is terminal, but along the way, it is important that we bear in mind that what we ought to have is a market that is filled with efficient entities, not, as the R3 would put it, zombie companies. Now, the fourth point is the reality, based on data, of course, that many administrations would exit into CVLs. In addition, we do suggest that some of those administrations are what we could describe or characterize as disguised liquidations. And on that point, we ought to acknowledge the body of scholarship in this area. Professor Walton and Key did write a paper on British Steel moving into compulsory liquidation. And of course, Post-Enterprise Act, the idea was that perhaps administration will be the new liquidation. And having seen some of the large compulsory liquidations, there is a suggestion that perhaps we are now seeing liquidation as the new administration. But the point is this: if we've spent a lot of effort on rescue, and we still see many of these rescue procedures ending up in liquidations, why do we continue to engage in, to our mind, very unhelpful duplication in procedures that could not improve the entire outcomes or indeed the fate of creditors in an insolvency scenario? Now, I should stress some points here before Sofia comes up. These thoughts are very much in their nascent stage. They are ongoing and will continue to improve on the course of our discussions and our research in this regard. And the second point, of course, is that many of these points are based on data. And of course, the usual caveat that applies to the use of empirical data applies, which is lies, damned lies, and statistics. Well, on that note, I think here's Sofia to do her best rendition of the musical Here's How We've All Wasted the Last 18 Years on Administration. All right.
Hi. Can you, yeah.
So since the Enterprise Act of 2002, there have been too many developments regarding administration. That includes the administration objectives, the powers of the office holder, transforming administration into a more rescue-oriented procedure, but nothing equivalent happened for liquidations. So no attempts to improve liquidations like in administration. So what we are exploring here is whether CVLs can serve as a counterpart in insolvency procedure and not remove rescue as a concept. So yeah, the title might seem provocative, but that's not what we are looking for. So administrations are basically distribution practices, and they are effective on a certain extent. We are not saying that administrations are not effective. And as we can see from the first figure over there, the objectives B and C are the most popular, let's say, for companies that enter administration. But administration is definitely not cheap. So that's one of the things that we are looking over there. Although there have been too many interventions on how administration operates, it seems that that creditor returns can be diminished because of the expensive procedure of administration. So administration, it's not the first option of distressed companies. It's liquidations that are the first option, as we've seen from the first figure from the previous slide. But the focus has been, in terms of policy, has been on administration and not on CVLs, let's say. So we argue that some policy needs to be taken to make liquidations easier to use and more attractive for companies. So objectives B and C of administration can also happen in liquidations, but at a much lower price, if you think about it. And we can see that CVLs can be a lot cheaper than that. And if we take, for example, the second figure over there, the IP remuneration for administration reaches almost £104,000, while CVLs is the 1/10 of that. So that's a major difference, and that should not be neglected. This fee can basically have a knock-on effect on creditor distribution. That's why expenses matter, because distributions might be less if the procedure is a lot more expensive. I mean, some caveats need to be taken into account regarding this data. Firstly, because there might not be enough statistical significance, just because there were more data on CVLs that we collected and less data on administrations. And the other caveat that needs to be taken into account is that in some administration reporting, we could not differentiate the IP costs from the IP fees. So another thing that we are considering is the value of a pre-pack CVL, especially after the initiation of the new regulation on pre-packs. This is mainly because they are lightly regulated and do not require the involvement of creditors like pre-packs at the moment. Also, the power of the liquidator of disclaiming owner's property makes the option of a pre-pack liquidation even more attractive, as it can potentially improve the value of the assets and offer more returns to creditors. So we have seen insolvencies of large corporations like Carillion and British Steel that chose to go for compulsory liquidation rather than administration. So the power of disclaiming onerous assets definitely played a role in that. So generally, there are better returns in administration than CVLs. The reasons for this include the decrease of the value of the assets when a company enters CVLs, and also the breadth of the powers of the administrator regarding business trading. As you can see in the final figure over there, the difference of the returns of unsecured creditors in CVLs and administration, it's kind of insignificant. It's really close. So, I mean, yeah, administration returns are slightly more, but the fact that the returns in both procedures is that low, it's concerning. And from the data that we collected, we've seen that in most of the times the returns to unsecured creditors are zero. CVL is the main procedure that the companies follow. It can be, we are arguing that it can be positive in some perspectives, and we believe that we should invest more time on liquidations and make them more accessible, and to distract companies more creatively, let's say. So back to Kayode.
Very much for that, Sofia. Now, I turn to certain observations on CVLs that, as I suggested in the first half of this discussion, may warrant further legislative scrutiny, if not intervention, so as to improve stakeholder confidence and outcomes in liquidations. And we are looking at CVLs. We are terribly indebted to the Insolvency Service for this data, because this was a collection exercise that we did earlier in the year on 2,071 CVLs. So that's what these observations are based on. But it's important to set these observations against the backdrop of the key rationale behind the introduction of creditors' voluntary liquidation. And we've taken these from the Green Committee report of 1926. There were two key issues for that committee. The first was how to improve creditor control or participation in a procedure where they have more skin in the game compared to members of directors or shareholders. And the second, of course, was there was a concern as to the lack of prosecution of misconduct of erring directors. Now, Sofia's already covered some of the upsides of liquidation and CVLs, including the use of the power of disclaimer, which is terribly important. But of course, the CVLs does not have the power of disclaimer, but nevertheless still stands as the most frequently used insolvency procedure in a corporate distress scenario. But what I want to do now is to turn to some less encouraging outcomes. Now, the first, of course, and this will be rather obvious, is that many of those cases that we observed or examined were asset-light cases. In other words, there was a paucity of assets. Now, the broad implication of that is that you would have little or no realization, very little work for office holders to do by way of realization, and of course, little to no return to all category of creditors. But that particular observation has led us to two further, and I think these are the key points there, two further observations. Now, the first is the fact that as a result of the asset-light nature of these cases, many office holders were decidedly happy, not to seek creditor approval for fixing their fees, since they would write off their fees due to the lack of realizable assets. So there was no creditor participation in setting the fees, but again, there was nothing to fix in any event. The second point, of course, was the high level of creditor apathy in terms of submitting their proof of debt or indeed participating in the entire CVL process. Now, that needs to be juxtaposed with the rationale again behind CVLs, which was to improve creditor participation or creditor control. The second broad observation that has caused us some consternation, which I now turn to, is the use of or the payment of pre-appointment fees by directors. So with pre-appointment fees, we're talking about fees, for example, for preparing the statement of affairs. Now, many of those fees in our sample anyways would range from about £1,000 to £15,000. On average, I think we charted that at about £4,200. And numerically, 1,700 of those cases out of the 2,000 cases had paid a pre-appointment fees or fee. Now, bearing in mind that many office holders had written off their actual IP remuneration, it seems to us that there was a bit of arbitrage going on. Now, by no means do we suggest that anything underhanded is going on. And I'm sure Caroline would also suggest that's not the case, but it's nevertheless, in any event, we're not paid very much to agree with the body of IPs, but we do recognize that IPs are doing quite a sensitive and commercially complex work. But it's important to stress this concern that if these payments are coming from directors, what does that mean for the entire insolvency polity? And there are two questions about the payment of these fees. One is that in any way, unintendedly, I should stress, affecting the investigative and reporting duties of office holders? Second, and to the point that creditors would usually get nothing out of this procedure settling from our sample, should creditors be getting some of that money that are going in terms of pre-appointment fees? Now, in conclusion, we've got some, again, ongoing or continuing thoughts, as it were. Now, the first, of course, is whether there is scope to consider asset-light CVLs and remodeling them as compulsory liquidations. Should we have a policy threshold for CVLs by reference to the value of available corporate assets? Now, of course, that's going to place a lot of burden on the compulsory liquidation regime, and that in itself poses two problems. One, how do you fund that? How do we fund the official receiver services? And I'm sure that's a question that the Insolvency Service continues to pursue in its new 5-year strategy. The second, of course, and we need to consider our private sector IPs, because there's a competition issue, because now we've got the state competing with the private sector IP in that regard. Now, these are some of the thoughts that we have, but on the whole, we do suggest, as we continue to look into this issue, that there is still scope to improve the outlook of liquidation. It's not just a terminal procedure. There is some residual, if not ongoing, value in a liquidation process for all stakeholders. And it is fitting to conclude this discussion with some well-considered thoughts that Caroline had shared in her June 2021 paper for the Corporate Rescue and Insolvency publication. As we continue to think about strategies for a post-pandemic economy, we ought to consider the nuanced nature of the distressed setting in which these insolvency regimes operate, the commercial complexities involved in the work that our IPs do. And so, to our mind, any strategy, and indeed any push from administration to liquidation, ought to toe the line of evolution rather than revolution. Thank you very much for listening. I will be happy to take your questions.
Thank you. Thank you very much. That was a really interesting paper to start the day off, and as you can see, I've made lots of notes. What we're going to do is have both speakers do both papers, and then we will take questions covering both papers at the end, if that's okay with you. But I have to say, I have to really agree with many of your comments that you've made this morning, particularly the need to be able to liquidate companies that have reached the end of their life quickly, effectively, and at minimal cost to everybody. So I'd like to now move on to our second paper of the morning, Rescuing Companies or Their Creditors, and the role of the company voluntary arrangement as a rescue procedure in the UK. The author of this paper is Sue Morgan. She's from the University of Nottingham, and with nearly 40 years in the insolvency profession as a trained accountant whose experience includes working in the Insolvency Service, the Joint Insolvency Monitoring Unit and a Big Four firm, I think Sue's ideally placed to look into CVAs in the way that she has. So, Sue, if I'd like to hand over to you to present your paper. Thank you.
Thanks, Caroline. Good morning, everybody. The purpose of my research into the CVA was to understand how the procedure had been used over a much longer period than anybody had ever looked at before. People had done snapshots, but I decided that what we needed is a proper 10-year longitudinal study. As you can imagine, the study produced a huge amount of data. I've got over 4 million data points and masses of data on virtually everything that's ever been filed at Companies House. So today I'm only going to provide, or only have time to provide, a very brief overview of the key findings. And one of the key recommendations that comes out of all that data is my suggestion for a CVA micro protocol, because it would make a huge difference to the number of both companies that are saved and businesses that are saved. But starting first with some background. It was mentioned earlier, but the two key elements of a modern insolvency framework are to support business rescue and to maximise returns to creditors. That is when possible. So the importance of saving businesses was originally highlighted by Cork in the 1982 report. So this is not a new concept. It's not something that we've suddenly decided to do in 2015. The rescue hierarchy was also set out by Cork, and this embodied in the Insolvency Act 86 and remains a key requirement in relation to post-enterprise Act administrations. The CVA was also a Cork recommendation, which is why it's sort of fundamental to my research, because it was specifically intended as a cheaper version of the scheme of arrangement, specifically for small companies. And unfortunately, that seems to not have happened. It's used far more often by big companies. So actually, how many CVAs are being approved? So since 1987, there has only been just over 15,000 CVAs registered across the UK. So again, I've looked at all three jurisdictions, not just England and Wales. So you're getting a full picture across how it's used in different jurisdictions. This works out as an average of less than 500 every year, with the annual volume never exceeding 1,000. So the volume of CVAs gradually increased until 2013, as you can see on the chart. And since then, it's been an almost straight downward trend. So that's shown in the first table on the slide. And the second table shows the CVAs as a percentage of overall corporate insolvencies, which was referred to in the previous presentation. And as you can see, that also is on a downward trend. So why is the CVA reported as being underused and ignored? It seems to have developed a reputation for failure and underuse, and principally because of the failure outcome of it. So unlike any other insolvency procedure, it's the only one that's actually, the outcome is properly judged or appears to be judged. And this is driven by the statutory requirement to terminate any arrangement where the terms are not fully met. So even if the creditors get paid a load of money, if one item is not met, then it's terminated, and then it has to go into another procedure. So this negative image was reinforced by the policy statement in 2015, which I've quoted on the slide, and it's become a self-reinforcing trend, which is why I think we've got this continual downward trend of use. Equally, the APPG report was a completely missed opportunity by the government to identify and report on the positive impact that the CVA actually has. And actually, I'm sure nobody else is aware of that either. So the CVA has been very successful at saving both companies and businesses, as well as paying much higher levels of dividends than in any other procedure. So when measured against the fundamental elements of the insolvency framework, the CVA is the only one which actually fares well against those criteria. So why is the CVA? What are the key attributes of the CVA? So despite its reputation for failure, it's infinitely flexible. It delivers debtor in possession solutions. It keeps costs low. And as a result of that, it ensures much better returns to creditors, again, than any other procedure that can be used. The CVA can be tailored to any scenario. It's often dismissed or overlooked in favour of administrations because that's quick and easy. The appointment is much more straightforward. They haven't got to rely on creditor support. So the key difference being the outcome for administrations are principally in the hands of the office holder, in contrast to the outcomes of the CVA, which are actually controlled by the management team, where you've got debtor in possession procedures. This CVA shows a comparison over from 2006 to 2019 of CVAs and admins combined, so the two rescue procedures, and it shows that the CVA is showing a slightward upper trend. So it's actually taking away some of the rescue market from administrations. It's clearly still not a first choice option, which is where it should be. It should be the first option you go to for a rescue, not administration. But because admins are still taking roughly 80% of the market. So I then decided to look at the rescue choice. Why is it people are choosing admins? Somebody comes through the door, rescue option, CVA admin. Because at the moment you've got 20% are rising, only going to CVAs, and 80% going down, going to admins. So this is the key point at which the CVA is often dismissed for the alternative. So once a company has entered administration, the chances of the entity being saved is remote. But if a CVA is chosen in the initial choice, then the administration option is still there if there's a subsequent failure on the CVA part. So it's still a likely alternative strategy with a very good chance that still all or part of the business might be saved. So from a rescue perspective, it's a much better option to keep your choices open. This is all the CVAs, total volume, approved between 2006 and 2015, that were fully implemented. So this slide shows the success rate the CVA is having in actually saving companies long term. So it's not just a quick fix, it's the companies are actually remaining active at Companies House. It's their final outcomes, and I've tracked them through right up to September 2021. And it shows that an increasing number of companies are remaining active. So you can see the trend line. So although the volumes are going down, the percentage of those companies that are remaining active is going up. So we're doing something right, but we just need to help that improvement. And these positive outcomes are just never reported. It's completely invisible. And there's all that gets, the CVA just gets this bad press of how it's a complete failure. So in actual number terms, the long-term survival of the company recorded in over 60% of those fully implemented cases, which is 1,181 active companies still in place as a result of good CVAs out of 2001 that were fully implemented. Even when the company can't be saved, the exit route for many was obviously termination, and then they fall into administration. And over half of those that I tracked over the 10-year period resulted in the business being rescued in whole or in part. So that's a further 556 businesses that have been saved out of 1,060. So in total, nearly 30% of all CVAs, regardless of whether they are fully implemented or terminated, result in either the company or the business being saved, which in my book is not a bad track record. The other element that we talked about earlier is the maximisation of the returns to creditors where possible. So this slide shows the allocation of the total realisations for all the study CVAs and the total amounts distributed to creditors. So during that period, £1.2 billion was paid back to creditors as distributions, which is nothing to sniff at, which is actually money that's gone back to creditors from the CVA estates. And that's actual figures that I've tracked from R&P accounts. Every single one of them has been analysed. And this represents over 86% of the total realisations that have been paid into the estates. So in terms of distribution levels, the average dividend paid was 15 pence in the pound, or just over that, with the annual average of distributions being between 8.5p in 2008 to 22p in 2014. It varied slightly from year to year. Distributions were paid in over half of all the CVAs, regardless of the type of completion. So lots and lots of terminated CVAs actually paid distributions to creditors. So tick the box on the returning money to creditors. And they got way more in the CVA than they would have got in an admin or a liquidation under any terms, under any circumstances, CVL or compulsory. So from that, you can determine that increasing the use of the CVA would provide a positive impact for creditors, giving them not only the opportunity to first save the company, second, save the business if the CVA fails, but the business is saved, but also a way better distribution level than any other procedure gives them. So who and what affects the use of the CVA? Identified 4 elements to investigate during my research. So to answer this question, I attempted to understand who or what was influencing that decision. So the 4 elements identified were the IP, or the IP's firm, because there is a subtle difference. And when I did all the analysis, which I'll talk about in a minute, it was quite clear there was quite some influence made by specific firms. The creditors, to get the CVA approved, because ultimately, unlike any other insolvency procedure, you have to have the creditors on board. The company, and then the legal framework under which it was working. Each was researched in turn, and the data sort of analysed to identify the root causes. So how did I do this investigation? So the data collected was from a wide range, and all the documents I used were publicly available. Large volume of documents filed at Companies House. Over 90,000 documents I reviewed in the end, and took all the data, put it onto a spreadsheet, and I have around 4 million data points now to analyse and give you the information. There was a similar number of CVAs, so again, just over 6,000 I looked at. Some of these were multiple use CVAs, where companies have used the CVA more than once. The data was analysed, and I used both path dependence theory and actor network theory to identify behavioural issues and other links. Path dependence is described as a way of improving our understanding of the ways in which our choices are affected by cognitive biases, political ideologies, and historical accidents. So an example, a simple example, is the QWERTY keyboard. So we're all used to seeing the QWERTY keyboard, and that was originally designed for manual typewriters so that the most used keys were not next to one another. So instead of having A to Z, you had the QWERTY keyboard. We don't need that anymore, but we still use the QWERTY keyboard. So that's an example of lock-in and path dependence. So we started using it, we've carried on using it, we've never changed. So it's the, I think intuitively we all know that history plays a role in our future choices, and path dependence provides a framework to analyse those effects and sort of brings clarity to complex issues when you're looking at relationships. So the 4 factors in path dependence are increasing returns, self-reinforcement, positive feedback, and then the lock-in is when you've got to the end of that process. But what you have to remember is everybody is at a different place in that process, and it applies to both individuals and organisations, which is why you can apply the analysis in a sort of dual way. So you need to know where you are in that process, your starting paradigm, and then you need to look at all the factors that influence you going forward. In contrast, actor network theory, which I also used, is a research method which with a focus on the connections between both human and non-human entities. So where you've got an object that affects something as well as an individual. An example of actor network theory is, say for instance, a chemist who is taking two substances, adds them together and gets a third substance. So when you're describing that process, you normally just talk about the actual chemicals. But actually the invisible element in that is the chemist. So actor network theory actually gets you to look for the invisible element that is interacting with all the different elements in research to find the invisible element to sort of tie everything together. And has been widely used in research into accounting reporting, and I used some of that in my thesis. So to investigate the impact on CVA use by IPs using the path dependency, the data and their firm data was recorded, classified by user type, with the super users, which were those that had taken more than 100 appointments during that 10-year period. So the slide lists some of the data here, which shows a polarised market with only 5 IPs or 10 IP firms taking the majority of all the CVA appointments. So clearly there is a lot of self-reinforcing behaviour identifiable for the super users, and a similar pattern for those IPs whose appointments completely excluded CVAs. So you've got path dependency for those IPs who never take a CVA. So it's actually, it actually shows quite clearly the behaviours and the actions across the whole market and why people get into these self-reinforcing behaviours and either use the CVA or don't use the CVA. And for super users, I treated them as effectively being at locking in this path dependency process. So again, I then turned to creditor participation in all the CVAs. Similar approach was used. So I collected all the debt levels, the voting debt levels, the number of creditors participating, and I used that to understand how they voted, their behaviour and the approval. And what soon became clear, HMRC was the single most influential creditor. They voted in over 80% of CVAs and with absolute control of the outcome in 54% of all CVAs. An analysis of the voting record using path dependency as an organisation indicated that they had then got themselves into this suboptimal lock-in level by simply voting sort of as an institution instead of trying to look at the outcomes for CVAs. So simply a small change in their approval protocol, I calculated, have resulted probably, you would have had an additional 1,875 CVAs with a potential additional distribution to HMRC of 56 million based on all their debt levels and the amount of control they had on each CVA. I then turned to the influence of the company structure. So I used actor network theory here, and the elements I looked at included the management team size, the structure, the company age, the financing that was available, shareholdings, assets, size, employee numbers, etc. And I put all this data into my spreadsheet and started looking for patterns and what was the link between them. So the links between each of the elements was tracked, and it soon became clear that there was two things. Company size, and in particular micro businesses, kept popping up. And the invisible element that clearly started coming out when I started looking at all the company accounts was financial expertise, or lack of it in this case. And this was the key issue in the underuse of the CVA. It sort of came out from all the data, kept being reinforced, you followed the arguments through, and that data kept coming up and up. So it was very clear that the micro business was the key to getting more CVAs approved and through the case. So then when I started looking at the requirements and why the sort of micro businesses are not using it, I focused on micro businesses and the need to target them. So what I was suggesting is a CVA micro protocol using a standard form with the nominee appointment being registered without the proposal being already drafted, because that is the hurdle that most micro businesses can't hit, because they don't have the financial expertise. As mentioned earlier, they end up having to pay a load of money to a firm to help them do it, and that whole front loading, and then IPs don't want to be involved because it costs too much to write the proposals. So it's the micro businesses that get failed by the system. So with that, you would register the nominee appointment. So that would be on the record at Companies House. So we could actually see how many of those then subsequently failed. And it would act in the same way as a notice of intention to appoint administration. So you would get an automatic interim moratorium. So you'd have to do away with having to use a separate moratorium. You appoint your IP as a nominee, files his appointment at Companies House, and you automatically get this interim moratorium. 28 days, a bit longer than notice of intention to appoint, but not serious enough to worry about the outcomes of it. And the nominee can then put together, using standard format proposal, and then deal with that, and then try and get all the creditors on board. So summarising where I am, we need to get IPs on board, increase the number of IPs using CVA rather than just the 5 that do the majority of work, or the 10 firms. And I think that is going to need some additional training, but the use of a standard format would actually get a lot of buy-in and save a lot of money. Ensuring the nominee appointment is registered before the proposal, just with a statement of affairs to show that the company is insolvent. Provision of the automatic interim moratorium, and then also to get HMRC on board, as they vote in such a volume of them, that if they see the use of this for a micro business, that they will automatically approve it. And that if they don't approve it, there's got to be really good reasons why not. And that is a very quick gander through 100,000 words.
Thank you, Sue. That was really interesting. If I can ask you to stay up here for questions and answers, and if I can invite our 2 earlier speakers up to the front as well, please. Thank you. We have some questions from our audience who have been listening virtually, and I'm also going to invite questions from the floor. But before we start, Sue, that was a really interesting talk on CVAs, and it was great to see the positives being promoted for once. £1.2 billion is not to be sniffed at all. And so often we focus on failure and lack of action, so it's great to see the value of the profession being lauded in that way. But for me, a CVA isn't a panacea. It's an insolvency process in itself, and it's almost a last chance for many directors to actually avoid liquidation. And it is an insolvency process, and there are consequences and issues that arise out of that in itself. For example, you've got a loss of credibility, you've almost got a loss of credit limits with suppliers, there's almost breach of contracts that come up, and it's a matter of public knowledge. And so there's a lot more at stake for a company that enters into a CVA. So I wanted to know, we've now got the restructuring plan, which is a rescue process. It's not linked to insolvency at all. It's got many advantages over CVAs. And in our view at R3, it can easily be applied to SMEs. It's flexible. You've got cross-class cram down by secured and unsecured creditors. Do you think that this is actually going to mean the end of the CVA as we know it?
No, I don't think so. No, I think that they're all too expensive. You know, restructuring plans. There's too much court involvement, and you know, Cork was absolutely right in 1982. You know, the CVA was there to be a cheap version of the scheme. The restructuring plan is just another version of the scheme. And so all you're doing is just actually doing what we were saying earlier. You're muddying the waters. There's now far too many insolvency procedures that basically there's too much choice. Are you missing my...
No.
Oh, right, sorry. So I think there's just too much choice, and that's the problem. So, and that's where path dependency comes in, because basically, when you've got, you know, you're a professional and you've got all these choices, which ones you go for? You go for the one that's in your comfort zone, and then you stretch it to fit what you want. So procedures are being stretched to fit what they want, as opposed to what they're intended to do. There's just too much overlap, and I think that's the problem now. We keep adding to the toolkit and not making clear when they should be used and how they should be used.
Yeah, it's interesting. One of the comments earlier on is really that rescue is a great concept, but it really does require directors to understand the signs of financial distress and seek early advice. How do we get over the current block of actually getting directors to see the value of taking early professional advice rather than leaving it to the last minute? Because with the best will in the world, if there are no assets and the company's dead, you can't rescue it, can you?
They're accountants. Absolutely. We've got whole millions of accountants out there who don't do a good job at getting companies and directors to get the advice early. So, and that's why I was saying financial expertise is the invisible thread. It absolutely is the invisible thread through everything. And I kept coming back to it and coming back to it. And you can see the CVAs that failed were those that didn't have any accounts filed. Mm. You know, and I've got all the data on filings and stuff like that, and it just keeps coming up. And it is financial expertise. So if you want companies to do better, there perhaps needs to be government help with making sure that micro businesses in particular, because it really is micro businesses, not small businesses, because they're actually quite big small businesses, but micro businesses get the financial expertise that they need.
No, I think we would agree with you on that. We've been calling for early advice and better education for directors for a long time. I think turning to our other speakers, one that you touched on the payment of pre-appointment fees by directors, and is this a cause for concern? I think for me, actually, it's a sign that the directors are being responsible, because there is very little alternative. If a director doesn't put their company into liquidation, then what is the alternative? It's dissolving the company or waiting for Companies House to strike it off. And a director actually putting their hand into their pocket to pay the pre-appointment fee, they're actually being responsible and doing the right thing, ensuring that their company is dealt with in the right way. Yeah. One of the suggestions that you were making as an alternative was to have a de minimis level for liquidations. And I was wondering what you were going to say about where does that leave those companies that actually fall below that de minimis level, because you create a big black hole. So what are your proposals for dealing with that?
Yeah, no, thank you very much for that, Caroline. I think in some ways it's all about looking at how we can best identify value. If we had to reduce insolvency into its barest form, it's all about how we best allocate value in an otherwise complicated scenario. And one of the key points that comes to mind is the point about how we best see an improvement in creditor performance in terms of their realizations, in terms of their return. That may very well be reopening the question of how best to use some of the funding that comes from directors. So I think at this point we're not really set in stone in terms of going that way, in terms of the de minimis level, as you put it, but it is a very valid consideration because in some ways, some of these CVLs, if we see CVLs as disguised administrations, in some ways, some of these CVLs perhaps are better fit in the compulsory liquidation process. But of course, who pays the cost, who pays the fees? But it seems a bit anomalous seeing £10,000 coming from a director, and at the end of the day, there is nothing in the entire kitty. Another way to put it for corporate scholars is, why are you giving up the benefits of limited liability? If you didn't pay for it, nothing would happen. You've got the benefit of limited liability. Unless, of course, you've done something wrong. Now, of course, we do not suggest that each and every one of those scenarios would involve some wrongdoing. But the real question for us is, what impact does that have on the officeholder's obligations? And I know I've sort of gone round the question in a different way to bring it back to what is most precious to me. But that reporting obligation, particularly to the Secretary of State, it's confidential, and there's no, all the stakeholders do not have a lot of insights into that, other than perhaps the director, should they choose to get that. And we don't get a lot of information. I don't think we saw any information about, other than the generic, paragraph that we've done, concluded our investigations, but there is no clear indication as to whether that's led one way or another in terms of potential prosecution. So there is some concern there. I think that we ought to bring to bear. And if I may just add to a point that Sue was stressing, and I think, Caroline, you were concerned about this as well with that question. If we've got too many options in terms of insolvency, and one of the reasons why we suggest that we might need to move from rescue is to the average man on the street, and that probably includes the non-institutional creditors, to be fair, insolvency is just insolvency. And we talk about trying to preserve value, trying to swell value, trying to enhance that. But if everyone sees insolvency as just that, without any clear idea of the differentiation in the procedures, we are coming back to what is very much a zero-sum game in terms of outcomes. Yeah.
Interesting, thank you. Do we have any questions on the floor? Mr. Baster.
Caroline, thank you very much. Sue, you may not be able to answer this, so it might be unfair. The suggestion that came from your description of CVAs is they are much more successful than is the general perception. And my question is, if they were used more and there was a considerable increase in volume, is there any way of knowing that those same results would replicate themselves with greater volume? Or is it likely that the more it was used, the less the return would be because the CVAs would encounter increasing difficulties?
That's almost impossible to predict.
Fair enough.
I think the analysis of all the different elements and where the pitfalls are and the viability issues, I think if lessons were learnt from that, then absolutely, because the ones that fail very quickly, and that's where you've got to look at why they failed, and that was pretty obvious maybe from the start, or maybe they shouldn't have been in it in the first place. But then you've got, from the data, we get that IPs are getting much better at fully implementing arrangements. That is going up. So the data is saying that we are learning, or the whole profession is learning from that and getting more CVAs fully implemented. So that is definitely on the rise. So it's getting that point to a point that if you then add a lot of extra volume, does that go down, or does that just level off? But regardless of, even if they fail, does it matter? You've had the opportunity to save it, and potentially you're going to get a dividend. You know, it's a no-brainer. You know, I would push them all into CVA first. And if it fails, it fails. They're going to liquidation or they're going to administration. Administration, you might sell the business or you might sell the assets. You go into liquidation, and equally, as my two colleagues here have said, there's quite a few where the business has been sold, and I've tracked all those as well. So I've got all the CVAs that then went into admin, I've tracked all that and got all their data and the financial side of that and what is coming out of that. But the best distributions are in the CVA, you know, so just go for it. You know, maybe it's a single point of entry, go for it, and if it fails, then fine, we can go to an alternative, you know, a super CVL.
Good answer.
Which will replace admins and CVLs.
It's an interesting concept, isn't it? We did, with Professor Walton, some research into CV outcomes, and one of the difficulties is really how do you measure success or otherwise of a CVA? Because, as you say, it might fail in year 2, year 3, but if the creditors have got a higher return by that point than they would have done if it had gone into liquidation initially, is that a failure?
And the 20% of live companies. You know, that's priceless. I'm sorry. You know, you've saved those companies, which you wouldn't have done in any other scenario. So, tick the box.
Thank you. We've got a question here from the gentleman in the front row.
Thank you. Thanks. Thank you. Two very interesting papers. I particularly enjoyed Sue's analysis of the CVA. In comparing different types of procedures, you have to be aware of the selection effect, because different procedures would have been selected in relation to particular debtors by the stakeholders who would have had reasons to select that procedure. So there would be reason to think that the companies which have gone down the CVA route would not be the same in terms of their characteristics as the companies who go straight into liquidation of one or other form. And the same is true in relation to administration as well. So the comparability of the outcomes, the performances of different types of procedures depends on us being able to pin down the similarity of the debtors going into those procedures in the first place. So if you find out that the companies which go down the CVA route tend to have, for example, a greater level of assets like for like, physical assets which can generate returns, or they have creditors who are more likely to support the decision makers there, whereas companies which go down the liquidation route straight away do not have a similar level of physical assets and do not have support of the creditors, then it may be that it's not so much the nature of the procedure, but the facts about the business of the debtor and of its management which are determining outcomes, not the nature of the procedure. And this would then take us back to Stephen's point, which is that just making CVAs more widely available may not replicate proportionally the success to date of the CVAs. I'm interested in your work as well in relation to comparing the outcomes of CVLs and administrations. As you know, CVLs are one exit route for administration, and frequently when there were assets available in administration for distribution to unsecured creditors, the administrator would then apply for the administration to come to an end and for the company to enter into a CVL where distributions would be made of value which had been generated within the administration. So I'd be interested in seeing how you compared the performance of the CVL versus administration, taking into account this confounding factor, which in my experience is very common, and how you controlled for things like the size of the company, because obviously the level of returns all of the evidence from multiple jurisdictions shows is determined in significant part by the size of the data.
I mean, the size does matter in terms of what kind of procedure you want to choose. I mean, CVAs, as you mentioned, are maybe more appropriate for larger. The CVL is an exit for administration, so that's also an option.
Did you differentiate between Section 100 and Para 83 type liquidations? I thought you would have done.
Yeah, absolutely. And just to add to the points, I think that's very, very helpful, Professor Mokol. It's very difficult sometimes when you're trying to sort of do these differences in analysis. One of the starting point for us, of course, was to isolate CVLs that are just straight, clean, neat CVLs, no pre-administration, not an exit to administration. Now, what we've not got to, of course, is to look at those CVLs that have actually performed as an exit in administration. But perhaps, given some of the historical work we've done, not much will come out of that, because usually a lot of, what you get in that in such a scenario is perhaps a distribution with the prescribed parts to unsecured creditors, and that happens in the CVL, and much of the other strategies have already been executed in an administration. It is important that we try to look at sort of the profile of the business. Now, I think that's the more complicated one. Straight off the bat, we could say that's a large entity, that's a small entity, you can look at that, but when you start to look at the different identifications of the debtors involved, and the role they are playing, it seems to be quite different. The role that a creditor is happy to play, perhaps an institutional creditor like a bank is happy to play in administration, is very much different to the role they're happy to play in a liquidation scenario. And much of that might be tied to the residual value in that company at that stage. Let me just give a quick example. Some of the scant evidence we've seen is that in a liquidation scenario, a secured creditor like a bank will perhaps just engage in terms of, okay, should we just fix your fee? And that's how much involvement they have in that process, and that's fine. But in an administration, it's more than that. You probably have, they've probably got a floating charge, and they're talking about, giving their consent to a potential sale of the business and whatnot. So there's much more involvement, what many of us in scholarship world will call much more secured control in administration, but that's not necessarily been exercised in a liquidation scenario. So I think there are still many, not just data points, but indeed real life nuances to examine, as you've rightly put. I totally agree with that.
Yeah, I'd agree. It's interesting. Creditor apathy is something that's coming through loud and clear from our virtual audience. And one of the questions we've got is, has deemed consent increased creditor apathy? Should we actually be talking about bringing about the Section 98 meeting so that creditors then have an opportunity to engage in real time again? What do you think?
Yeah, I actually think that was quite a funny one, because I thought post Small Business Enterprises, Employment Act, that would make it easier and that would improve, the lack of creditor participation. But again, it comes down to how much skin you've got in the game. I think that's what this is coming down to. If there is no value in the company, there is no point in getting involved. And perhaps that decision procedure, or indeed the deemed consent, not the qualifying decision procedure, is not necessarily doing what it ought to do in that regard. Not due to its fault, but because there's just no assets. It's by the sheer definition of insolvency, particularly in that sort of procedure, there wouldn't be much to go forward with. I think a further interesting question is whether, the qualifying decision procedures could be used in a more comfortable way. And we didn't see much improvement in that regard. There was a lot of qualifying decision procedures in terms of remuneration and whatnot, and that's going on electronically. But again, if there's not much to come to the creditors by way of realization, it's not the deemed consent procedure in particular is not necessarily being utilized as much as it ought to be. So I think it comes back to the available assets.
Yeah, I think it'll be interesting to see what the outcome of the insolvency rules review is on that regard. We have a gentleman in the blue shirt over there.
Thank you, Caroline. And thank you for your presentations this morning to all of you. Interested in talking to all of you, but perhaps separately. Just one big issue for me that probably affects both of your papers is the reintroduction or introduction of HMRC preferential status. I've been a supervisor of CVAs. I've, tried to. They're really hard to get off the ground, by the way. They are hard work. But how do you think the introduction of HMRC preferential status is, for much of its liabilities, will impact the viability of potential CVAs, given the huge amount of tax debt that has been built up in the economy over the last couple of years? And is this not a big hurdle, another big hurdle to get over when we're looking at setting up CVAs, and actually in CVLs, in achieving creditor engagement? Because actually, you just said, creditors need skin in the game. It's all going to the taxman.
Yeah, I mean, I did do some sort of back of the envelope calculations of how that would, and I went back through all my 10-year data to try and work that out. I haven't got all the numbers on me. It was quite a big figure because I worked out exactly each CVA I went through. I calculated which one would then effectively, HMRC would get more of the money from the unsecured. So I had columns, so I knew who was being paid what of each distribution, whether it was a secured creditor, whether it was a pref creditor, whether it was the remaining unsecured creditors and so on. So I did do some figures. It was quite big, the number, but at the top of my head I can't remember without going back to all my paperwork. But yeah, it's going to make a difference, but it's like anything, that the returns are still bigger out of a CVA than anywhere else. And I know they're hard work, which is why what I'm suggesting is that the format is simplified and that you haven't got all this arguing about terms and all the rest of it, that if you've got a much more clear process that hasn't got to be written from scratch every time, and that everybody signs up to. So you've got to have everybody on board. You've got to have IPs on board, you've got to have the creditors on board, you've got to have HMRC on board to make it work. But I'm hoping that the pandemic has actually changed people's minds about things, that people are being a bit more collaborative instead of it doesn't suit me, so I'm not going to do it. But actually, and maybe HMRC will then think again, or perhaps the Treasury will think, actually, and the reason why they brought it back in was because the prescribed part hadn't worked. And the prescribed part hadn't worked because it was not retrospective. And when I went back through all my 6,000 companies and I tabled the date of every charge on it, and I could work out exactly which ones, and there was virtually none that the prescribed part applied to, because they were all older charges. So of course it wasn't going to work, and as all you were doing is giving money away back to the secured creditors. So it's catch-22. So I can understand why it's come back in, but perhaps the thought process behind it in the first place wasn't really thought through. Everybody thought it would kick in after a year or two, but it hasn't. And we're 10 years down the line now. So it's like anything. You try something out, and if it doesn't work, you change it. You've got to be flexible with this, and that's why the CVA is so good, because it is so flexible.
Yeah, I think key to all rescue procedures is HMRC actually standing up to its commitment to support reasonable rescue proposals putting forward, but time will tell. We've got time for one more question from the floor, and I've just got one interesting comment that did come through from our virtual audience. You mentioned about how do we fund the insolvency service going forward, and a suggestion's come through that the annual confirmation statement fee paid by all companies could be used to support the insolvency service rather than just relying on those companies that go into compulsory liquidation. So that's just a suggestion for you when you're looking at your 5-year plan, okay? And I think the lady at the back actually has had her hand up for quite a while. Apologies to anybody who I haven't managed to get to.
Thank you. It's Inga West, and thank you very much for your excellent presentations. I really wanted to address this sort of comment to the right-hand side of the table. You seem to ascribe, I mean, you touched on the real sort of principle debate about what the purpose of insolvency is, and you seem to subscribe to the school of thought that once a company has failed, the purpose of the insolvency regime is to quickly dispatch that company and return the assets back into the functioning economy. Of course, the other school of thought in relation to insolvency regime is that there is a benefit to rescuing a company even if you rescue it for a while. You then return that company back into a sort of functioning state. It has employees, it pays taxes, it pays suppliers, and even if it subsequently fails, that's still, in some sense, a success. I think if you take it too far, of course, you then become too fixated on rescuing the company, and I think there is an element that the country has been too fixated on rescuing companies ever since a certain politician stepped off a plane back in, just before the turn of the century and said, have Chapter 11. But I wonder whether your point of view is also too narrow.
And you've got 10 seconds, I'm afraid.
Sorry.
I shall do my best. Thank you very much, Inga. I think that's the kicker. It's a balance. We ought to rescue, but the point is ensuring that eligible companies are eligible for rescue go into the right rescue procedure, and companies that are not eligible for rescue go into the liquidation procedures. How do we properly identify those companies? That is the question that we, and I suppose the members of the Insolvency Service, are going to be answering over the next few years, I suspect.
Yeah, it's something that's going to keep us awake for a while. Thank you very much, all of you.